Hey, good afternoon, everybody. Welcome to New Opinions. Charles saying this is a really quick read. I just heard about this one this morning. Essentially, there was a protection motion that was filed by Jack Smith and team against Donald Trump after his latest post. So I'm just going to jump right into it and read it. And here we go. In the United States District Court for the District of Columbia, United States of America versus Donald J. Trump, defendant. Government motion for protective order. The government stands ready immediately upon the court's entry of a protective order, in this case, to produce a substantial amount of discovery to the defendant. Discovery that defense counsel stated at the initial appearance yesterday that he needed in order to abide by the court's order to pose a trial date. And estimate the length of the defense case to allow the government to begin producing that discovery, much of which includes sensitive confidential information. The government respectfully moves the court for entry of the attached proposed protective order governing the disclosure of discovery by the parties in the above captioned case. The court can and should enter it immediately to allow the government to produce discovery, because the defendant can seek at any time to modify the order if he objects to it. Background. On August 1st, 2023, the federal grand jury in the District of Columbia returned an indictment charging the defendant with violation of 18 U.S.C. 371, conspiracy to defraud the United States, 18 U.S.C. conspiracy to obstruct an official proceeding, 18 U.S.C. obstruction of an attempt of obstruct an official proceeding, and 18 U.S.C. conspiracy against rights. On August 2nd, the government sent a proposed protective order to counsel for the defendant. Defense counsel substantially responded on August 4th, today, with a different proposal, protective order that did not, in the government's estimation, protect numerous categories of sensitive material, including grand jury material and sealed search warrant affidavits. The same day, in an attempt to reach a compromise, the government drafted a new proposed protective order, modeled on the one entered by Judge Carl A. Nicholas in a recent criminal case, and provided it to the defense counsel, noting that the government intended to file a proposed protective order today. In response, defense counsel asked the government to note in this motion that they did not have adequate time to confer. Argument. The government seeks to provide the defendant with discovery as soon as possible, including certain discovery to which the defendant is entitled at the stage of the proceedings. The attached order would allow the government to do so while also protecting large amounts of sensitive and confidential material contained within the first production that the government has prepared and will send as soon as the court issues an order. Such materials include, but not limited to, materials containing personally identified information as identified in Federal Rule of Criminal Procedure 49.1, Rule 6, materials including subpoena returns, witness testimony, and related exhibits presented to the grand jury, materials obtained through the sealed search warrant, and 2703D orders. Sealed orders obtained by the government filter team related to this case. Recordings, transcripts, interviews, reports, and related exhibits of witness interviews and sensitive material obtained from other government entities. The court, for good cause, entered a protective order governing or redirecting discovery or inspection. Fed Art. Prim P. 16, also see United States versus Cordova. A trial court can and should, where appropriate, place a defendant and his counsel under enforceable orders against unwarranted disclosures of material they may be entitled to inspect. Quoting Alderman versus United States, courts regularly do so to expedite the flow of discovery in cases involving large amounts of sensitive information. United States versus Johnson. When seeking a protective order, the government must establish good cause. United States versus Dixon. Here, good cause exists because issuance of government proposed order would expedite the flow of discovery, in this case, give a defendant prompt access to a large portion of discovery he ultimately will receive, and protect the highly sensitive categories of material described above. The government proposed order is consistent with the other such orders commonly used in this district and is not overly restrictive. It allows the defendant prompt and effective use of discovery material in connection with his defense, including by showing discovery materials to witnesses who also agree to abide by the order's terms. All the proposed order seeks to prevent is an improper dissemination or use of discovery materials, including to the public. Such a restriction of particularly importance in this case because the defendant has previously issued public statements on social media regarding witnesses, judges, attorneys, and others associated with legal matters pending against him. And in recent days regarding this case, the defendant has issued multiple posts, either specifically or by implication, including the following, which the defendant posted just hours ago. Quote, "If you go after me, I'm coming after you. Donald J. Trump." If the defendant were to begin issuing public posts using details, or, for example, grand jury transcripts obtained in discovery here, it could have harmful, chilling effects on witnesses or adversely affect the fair administration of justice in this case. See Gentile versus State Bar of Nevada. The outcome of a criminal trial is decided by impartial jurors who know as little as possible of the case based on materials admitted in evidence before them in the court's proceeding. Extrajudicial comments on or discussion of evidence which might never be admitted at trial obviously threaten to undermine the basic tenet. Finally, and importantly, the government's proposed protective order would provide that either party can seek to modify the order at any time, meaning that the defendant is in a better position if he receives discovery under proposed orders conditions rather than receiving no discovery while this motion is pending. If the court issues the government proposed protective order forthwith without awaiting a responsive brief, the defendant will be free to review the discovery that the government will promptly produce and can seek any modifications of the order that he determines appropriate based on that review. And once in the possession of the government's detailed organized discovery inventory, the defendant will be in a better position to assess and justify whether to seek a modification to the protective order at all. Respectively submitted, Jack Smith, Special Counsel. All right. There you have it, guys. That is the order that was requested, and be interested to see what your comments are. And also, I'm going to be interested to see what the response is going to be from Trump's team. Like I said, I get tired of just hearing people comment on what the documents say, what they think it's going to do, or what it should do, or, I just want to know what is being said, because at the end of the day, all that commentary is useless. What really matters are these documents, these arguments, and that's going to be in between those pieces of paper is going to be the determination of who wins or loses. So all the arguments that the lawyers are making in these documents, that's the meat. All that other stuff, I ain't got no need for it. If you enjoy this type of content, I ask that you please like and subscribe. And any feedback that you can give me to help me make it better. Like I'm trying a new setup this time. I'm just using an earbud and the phone and with the Bluetooth recording. So anyway, hope you all have a great weekend. Can't wait to see what the response is going to be on Monday.